All right. Well, I'm with Paul Lesko, otherwise known as the Hobby Lawyer, a plaintiff's litigator. Paul, thank you so much for hopping on the channel today. Really appreciate you taking the time.
No, thanks for having me on.
Yeah, it's really cool to get you here because I am not an attorney. I cannot speak legal language to any interesting degree. So you're gonna have to treat me like I am a third grader throughout this entire conversation. But I think that that's a good thing because I think that's why it's really exciting that you took the time to kind of take a look at this, because I know for people who know about you on your Twitter, you spend a lot of time kind of looking at the sports card world, the sports card market, and sort of a lot of the legal happenings that occur in that space. And you kind of jumped over to the CGC thing and recently kind of revealed the two employees that CGC filed a lawsuit with, and now also this Reholder lawsuit as well. So it's great that you are covering this as well. We need you here on the comic book side to kind of explain some of this stuff. So really appreciate you taking the time and being here.
No, thanks. And that's exactly what I want to do. Because, by trade, I'm a courtroom lawyer. And most of what I do is try to explain stuff to judges or juries. And so for fun, what I do is, I collect cards. I'm involved in the hobby. And anytime there's any lawsuit that's out there, I like to take it and try and explain it to everybody, because that's really all my job is, taking complex issues and trying to simplify them. And if I can get a lawsuit like this and explain it so that people on Twitter can follow it, then I'm doing my job. If I can't do it, well, then I have to go back and work at it, because if I can't explain it on Twitter, I'm certainly not going to be able to explain it to a jury at some point.
Right. Well, let's start with the Ulysses Zanello lawsuit, which is the one, of course, many people who are watching this or have been following the comic side of this scandal is going to be the Reholder one. I'm not going to spend too much time talking about like what had happened in the Reholder stuff. I kind of want to get in the nitty gritty because I think that that's what people are going to be most interested about. But let me start here.
Sure.
The lawsuit has been filed, and CGC is now in this place where they're doing whatever it is that they need to do, getting their case together, discovery, I guess this is what that time is. And then now Ulysses Zanello, he's got to do whatever he's doing. What is happening like right now? Like today when CGC lawyers woke up this morning and are sipping their coffee, what's on their agenda? And what's on someone like Ulysses Zanello's agenda? Like what's kind of going on?
Sure. So this, the way that this lawsuit is set up, it's kind of out of the ordinary, because normally, you're right, when you file a lawsuit, cases take forever. You file a lawsuit, you serve the other side, you wait 30 days, they answer. It just takes forever. But in this case, CGC is trying to move as quickly as possible. They're moving for what's called a temporary restraining order, where they're asking the judge to, as quickly as possible, look at everything here, get us a hearing. We want to shut them down now. Mm-hmm. So unlike other cases that you wouldn't get relief like this quickly, CGC is very much trying to get this done as quickly as possible. So it wouldn't surprise me if we didn't see a hearing or have a hearing later this week or maybe early next week on these issues. So if you're CGC's attorney, what you're doing right now is you're basically calling the judge's chambers every day. Hey, can we get a hearing? Can we get a hearing? Can we get a hearing? And on the other side, if you're the defendants in this case, you're trying to get a lawyer. You're trying to get your lawyers. You're trying to get them to maybe get you an appearance in the court. And so that, if you have a side, to get your side out there. So this case will move a little bit quickly at the beginning.
Gotcha. And so what would have been their experience, from the defendant's side of this? They would have gotten immediate letters from CGC's lawyers, and that would have been an indication for them of like, hey, you guys better make some phone calls right away. Or, what would have been, or what are they dealing with right now?
Yeah, I'm sure they had some contact with CGC's lawyers, but in order to officially start a lawsuit, you have to be served with a lawsuit. And that's a specific process whereby a process server shows up to your work or shows up to where you live, gives you a copy of the lawsuit so you have it in person, so that process server can go back to the court or go back to the other side and swear at an affidavit saying, I gave this person a copy of the lawsuit. You do that so that there's notice that there's actually a lawsuit. So that's as soon as the defendants in this case get that, that's when the case should start. But sometimes with temporary restraining orders, a judge will pick that up and rule on that right away sometimes. So sometimes you don't even need a hearing.
Gotcha. So what I was able to gather from, the documents that you shared on your Twitter, the crimes that were specifically stated were trademark infringement, false advertising, and breach of contract. So would you be able to kind of just talk about those three crimes and how they may relate specifically to sort of this comic book CGC situation?
Sure. And, before I do it, there's kind of a difference between crimes and unlawful conduct. So for a crime, it would be the government, would be prosecuting you. Either a U.S. attorney or a district attorney would be prosecuting you.
Right. And this is a civil suit, not a criminal case. I was going to ask you about that distinction later. But
Correct.
Yes,
Correct.
Thank you for clarifying.
Yeah. So when it comes to trademark infringement, and really all the claims are some variation of trademark infringement, which is basically, hey, judge, the other side here, the defendants here are using our trade name or our trademarks or things that people recognize us for to cause confusion out there. So in this specific case, they're using the CGC they're using the CGC slabs with the comics improperly, but they're confusing people into thinking CGC did this. So it's basically you're using CGC's trademarks, what CGC is known for, in an improper fashion.
Gotcha. And then what about false advertising? Is that sort of similar in this sense?
They're actually all in the same thing. So federal court, there's Rule 43, Lanham Act Rule 43, which covers false advertising, trademark infringement. It covers everything. And it's just, I always try to make things as simple as possible. There's like 6 or 7 causes of action here, but they're all really the same. They're using CGC's name, or they're using our holsters improperly in a way that is confusing people into thinking that we graded the comics like this, or that we're involved somehow in this, and we're not. Got
you. Now, let me touch on that for a second. I actually want to pull up your thread that you actually posted here on your Twitter. And highlight this one thing, because I'm putting on my defense attorney a hat right here, and I just want to see if there's anything here in this specific language. Later on, they say they are actually receiving swapped comic books resealed in CGC holder with false grading information. And I felt like when I was reading this, there was an emphasis on the false grading information. And CGC, we've had discussions in the wake of this entire reholder situation where, they're certified guarantee company. And in their guarantee, what they only guarantee is that 2 graders looked at it and the collectible is authentic. Mm-hmm. So if I take a lower graded comic book and I swap it into the reholder, but it's the same comic book, technically the comic is still authentic and it still maybe was looked at by CGC graders. So they don't guarantee the grade. So is it still like, I mean, clearly I'm doing something shady, but like, if I'm trying to really, get into the weeds here, like, is there something that, you can Floyd Mayweather this, kind of thing?
Not actually with this. So what if I'm the plaintiff's attorney, in this case, if I'm CGC's attorney, what I argue is the people that are paying a premium for a CGC graded comic or a CGC authenticated comic, they're paying for, hey, CGC is the last person to actually touch this comic. They put it into the slab and they sealed the slab. That's the comic CGC looked at. So here, since you have basically reholdering or swapping out a new comic there, the consumer, the person who's buying this, still thinks that's the CGC originally looked at comic, when in actuality, it's another comic that was taken and put in there. So I would say that's not a successful defense there, because you really need to look at it. And that's what's funny about trademark law. You look at it from the eyes of the consumer, not necessarily CGC or not necessarily the defendant. It's what does the consumer think?
Gotcha. So to that point then, maybe you'd be somebody who is like, there's no such thing as a slam dunk case, but in your eyes, is this going to be one of those things where this is a slam dunk case for CGC? Like if you're their lawyer, are you like, oh man, I got another W coming on my win column?
So the way I look at cases, there is certainly never in court is there a slam dunk case. I've won cases I should have lost, and I've lost cases I should have won. So you can never do it. But as a plaintiff's attorney, and especially as a plaintiff's attorney practicing in intellectual property, I reject 90 to 95% of my cases, if not more. So the best way I could summarize a case is if I look at a case and say, would I have taken it? Well, then I think that's a good case, or, you know, a slam dunk of a case. Here, I would have taken this case. So I think it's a good, strong case for CGC. But as a wise partner of mine once told me, your case is only as strong as on the day that you file it. After that, it only falls apart. So we don't know what the defendants, I mean, I think the defendants are going to have to come up with something pretty inventive here in order to put on a defense. I think CGC's lawyers did a great job with side-by-side comparisons and everything. So I think it'll be difficult. But to backtrack to it, this case is as close to a slam dunk as you can get out there for a case of this type. Unless the only better thing you could have is an admission. Like we have a recording from the other side saying, yes, I totally did this.
Right. Which, you know, there are some recordings, right, that were part of the documents that the person, you know, I don't know what you would call these, like clearly showing regret, or, you know, there's not an admission there, but I think, you know, the language he said was a mistake was made. Would you classify that as an admission?
Yeah, I would too. It's a huge mistake has been made.
Okay.
Yeah. And I mean, the fact that it was the timing there, I wouldn't say it's a smoking gun, but it's close, because you remember you have to look at it from the eyes of the jury, and the jury here is going to see the Instagram posts out there causing concern were there. A couple days later, he's calling up CGC and saying, hey, I got 3 things there, I need them back, it was a huge mistake, please call them, please get them back. So it looks bad. It's not a smoking gun, but it's about as close as you actually get in real cases.
Right. Let me continue down here on some of the filing. So, you know, you did a great job. And again, anyone out there, you know, I will put Paul's Twitter link in the description. So please give him a follow if you're interested in this stuff, and he will do a better job explaining anything that I can. So you go through here, you know, the case and everything. It mentions that, you know, they had some eBay accounts where they were selling this stuff through. And then here's kind of the really big part that, you know, became sort of the new talking point in the comic world, where it says CGC alleges that Zanello and Riva submitted 2,000 plus comic books to CGC under Zanello's account and through a dealer account for Comic Book Station, Comic Book Underground, that Zanello improperly got permission to use from that account owner. So 2,000 comic books were submitted. CGC released a list that 350 were like maybe, you know, tampered with or whatever was it. Like this was their first, like, hey, if you have one of these books, you know, maybe you should send it back to us. I think in the weeds there, it says 369. My question to you in this is, these books, you know, if we're to take that the 369 comics that went through the reholder program are the ones that the crimes were committed from, and those ones are now like evidence or whatever you would want to call them. Well, he was taking out comics from these reholders that were the grade that they were being advertised and putting in lower grade ones. And so certainly the lower grade ones are, you know, part of this, you know, situation. But it's also saying there that he submitted 2,000 plus books. So it stands to reason that once he took those higher grade ones out, he resubmitted them for grading, and then he was able to sell those ones as well. Would those books in the market also be part of evidence in this case? With like, if you're somebody who bought one of his books that were these, not the reholder one, but the one that became the new submission, do you also have cause for concern, or do you also have a case against him, or what are those books within this?
It's a mess. I mean, it really is, because you're right. Those are evidence. That is evidence of wrongdoing in those cases. And technically, you know, if you try and trace back who owned what at which point, I mean, you know, the original owner of who thought they were buying this comic, do they have rights against somebody else buying, actually getting the other comic after it's been regraded and sent out? So it's kind of a mess. I don't think a court here would unwind any deal where somebody bought a comic that was one of the reholder, you know, for the reholder people, they have their own issues. They could probably, you know, sue for, you know, what they thought they were going to get, the amount of money they overpaid. There's, you know, there's actions like that they could potentially go for. For the people who bought the actual comics that had been removed and then regraded, you know, it's a little bit more difficult there. I mean, I think those people, you know, probably paid full price.
Yeah.
Most likely they're all innocent. They probably didn't know there was something going on. So it's just it's a mess. I mean, I think you
Yeah.
can see a lot of people lawyering up.
Yeah, I suppose technically, like they haven't been tricked or deceived in any way because they still just bought a comic that is now the actual grade. But I just wonder if I assume that CGC is just going to like not worry about those ones, or if you're somebody who like, hey, you noticed on your PayPal, I bought a comic book from such and such eBay account, but it is the real thing. Like are those people, they should just sort of say, hey, all right, my comic is my comic, I'm not going to worry about it? Or do they have to worry about, CGC coming and saying like, oh, we have to bring back all 2,000 of these comic books and things like that?
Yeah, it's going to be difficult to predict what's going to happen there, because even if you are somebody who thinks you bought an actual the actual graded comic from CGC, there's doubt in your mind. I mean, you might want to submit that back to CGC as he had that one be reholdered, because it sounds like these guys think they had a pretty good scam that they wanted to do, and who knows, maybe they submitted something that was originally a 9.7. Sent it back in, got a 9.8. And they're like, well, you know what? We can make more money with a 9.8 and putting something else in here. So, I mean, who knows if they actually ever sold the 9.7s or the 9.8s, the actual good ones, or if they just kept reholdering. And those original ones still might be sitting in a shop somewhere.
Yeah. Yeah. Well, I know you can't give specific legal counsel. We'll table this and I'll ask you about, some other sort of speculative things, just on a personal level of those types of situations. But let me kind of carry on here. Now, what was interesting is that store was named Comic Book Station, and they were using his account to submit through, or submit through them. My question is Comic Book Station liable here, or like should they be getting a lawyer? Like would CGC lawyers also be looking into what they may have done, or are they just going to go after this one person? Or would possible lawsuits come later where it's like, oh no, CGC has another lawsuit against Comic Book Station?
Yeah, as I am more aggressive as a plaintiff's attorney, I tend to, follow the adage of sue everybody and let the judge sort it out. So here I would, put together a, list of everybody who touched these comic books before they were sold. And, if there's evidence that supports, any wrongdoing, I would have sued everybody. Here, maybe CGC's attorneys looked at the evidence and said, well, there's not enough here to potentially sue that comic book store. However, if I'm that comic book store, I'm a little bit nervous. I probably get an attorney just in case. Might want to reach out to CGC too preemptively. If you haven't done anything wrong, reach out to CGC and say, hey, look at my stuff. Maybe I can help you in this case. I was just as duped as you are, if that's actually what happened there.
Yeah, one of the things I thought was interesting, in the language there, when it was talking about the store and them submitting through this comic store with their dealer account or whatever. And then I think in the language, it said something like, oh, this is like against CGC's terms of services that they were able to use this and all this. And my question here is it's against their terms of services, but I think this is a pretty common occurrence within the hobby that stores will take customer submissions and do it on their behalf, or there's pressing and cleaning within our hobby, not quite as much in the baseball world, but sports card world. But pressers and cleaners will clean your books and make it all nice, and then they'll submit their books on their behalf. And so does this get into this slippery slope of hey, if you're a comic book store taking, submissions for your customers and friends, or you're, a dealer doing this, is this sort of the risk that comes with this? And would you sort of advise maybe people not do these types of things in the future?
That's interesting. I would right now, the way it's set up is, if I was stores that did this, I would be watching this lawsuit. I mean, you figure most of your customers aren't doing anything like this. So I understand, the group submissions, you're probably getting discounts. You think you're doing your client base a solid favor by doing this. But in the end, if this comic book store is brought in and there's some type of liability held against them, you might definitely want to look at your business model and maybe adjust. Is it worth making an extra $100 or $1,000 or making your customers happy if you can ultimately end up in court if you have one client, one customer out of your entire store doing something bad?
Right. I want to go back to the trademark infringement thing with the CGC. It mentioned, or you broke this down really great in the thread. there's some books that went into the reholder. There's 369, and those are the ones that went back through CGC's doors, presumably. But then in the language, it said sometimes they would even skip the reholder process and just sell, like, maybe he would just swap in a book and sell it at some Comic-Con or something like that. Is there any worry for CGC in terms of like how liable they are here, where what happens in the secondary market? Like, do they bear any responsibility? Because it's like, once some other dealer has it and then they're selling it, and like, I'm sure there's all types of tamper shenanigan stuff going on. Like, a big conversation in our side of it has been like, oh, they should improve their case security and all this sort of stuff. But like, is that something that they have to worry about? Is that really on them? Like, how much does this open a can of worms to that aspect for them later on?
Yeah, I think so. I kind of look at it, and the trading card world has gone through variations of this too, where it's kind of an arms race, where the graders come out with their case, and at least initially, nobody can break into the cases. Then somebody figures out a way to do it. So then at that point, it kind of, under like a negligency kind of standard, becomes a burden onto the graders to potentially have a better process, a way that people can't hack into it and swap stuff out. So I would say that, for an instance like this, I'd say there's pressure now on CGC to potentially up their safeguards, up their protections for new things. Because, I mean, here, if there were, 369 comics submitted for reholdering, that's, not an isolated incident. It's not like there's 3 or 6 or 9 where, somebody could just be, Houdiniing this and figuring it out. I mean, if you have 2 individuals submitted 369, that almost looks like you have a very serious problem with your cards there. So I don't think it would fall to the level of fraud or anything like that. I think it's, potentially, some type of breach of warranty type claim in the future, where if CGC doesn't improve what they're doing, that, they're saying that they're offering this sealed case. And if a percentage, even a small percentage, but an actual percentage of what they're grading can actually be reholstered, well, then that calls the whole, their whole thing into question. So I'd say, maybe in the future you could see legal issues on this front too.
Right. It puts some pressure on them for sure. Speaking of that pressure, last little thing, kind of going through the whole filing, there were certain books that went through an auction house called Comic Link, who, they also sort of fronted him the money. And that's not really that weird of a thing. Auction houses will do that, pay people in advance to get their books and consign and everything. I guess my simple question is, like Comic Book Station, are auction houses like Comic Link, are they worried about this stuff? Are they looking into what they need, what implications they have, their lawyers, that sort of stuff? And I guess entities like eBay or other selling platforms that have been used for this scam by this person, what are they thinking about right now?
Yeah. So, I mean, it's eventually going to be, it's going to look at where is the money going to come from to make people whole? Because generally when you have cases where you have 2 individuals that are doing this, they're not what's known as deep pockets. They probably don't have sufficient money to make everybody whole. If they conducted this and did this business, they probably don't have enough money to make everybody whole. So in that case, you actually have a number of people that were hurt that are going to look to try and get their money back somehow. Would they want to sue the auction houses or the sellers of these? Would they want to sell, potentially, you could potentially sue the graders here. It's a new area. It's kind of the wild, wild west to try to figure this out. But I mean, it wouldn't surprise me if you didn't see somebody sued, these 2 individuals, and then sued CGC, and then sued an auction house, or sued eBay, tried to sue eBay, or something along those lines, because, some people could be out significant money here. And if they can't get it from one source, well, maybe we can get it from all sources put together.
Right. So that those are sort of, in my opinion, like the kind of the big broad strokes of, the interesting things within the case. What kind of timeline are we looking at for this? I mean, I know you mentioned at the beginning, like, you wouldn't be surprised if they're like, hey, let's get the hearing like later this week. In a case like this, do you think that this is something that gets done pretty quickly? Does it drag out? Is it unpredictable? What's your feeling on this?
So it really has to do with are the defendants going to fight? If if CGC is able to get a temporary restraining order pretty quickly against them, that puts a lot of pressure on the defendants. And it's not just CGC asking to shut them down; they're asking for a lot of documents and a lot of materials to actually be given to them to start the case. In cases like this, sometimes you're really just bringing them to shut down the other company. If the other company agrees to give you, the other people agree to give you everything, say they're never going to do this ever again, are willing to sign an injunction or agree to an injunction that they would never do this again, and maybe pay CGC some money. Maybe that's all CGC wants. So there is a potential avenue that this could wrap up quickly. However, if the defendants want to fight here, it could take 18 months. It could take 2 years. I have a feeling this one will be fully resolved, at least from CGC standpoint against these defendants within the 6 months, though.
Right. And so what kind of penalties, you kind of implied it right there in your last statement, but like what kind of penalties are they looking at? I mean, in the case it said, oh, maybe it's valued up to $4 million of all this inventory and stuff. And, if I'm going to assume the defendants are not, liquid enough to, pay everything, like what kind of penalties are they going to get here? And if it is like, yeah, you owe us $4 million or whatever it is, like, are they just going to be on sending them checks once a month for the rest of their life? Like what is it going to look like on their end if everything is found to be proven true?
Yeah, it's when it comes to trademark infringement, you're really looking at a reputational harm. It's like, how much have these individuals harmed CGC? That $4 million they mentioned, because that might be an amount of money that they might seek. I think it's going to be hard for them to get that. But there's actually was a comparable case in the trading card world that just happened, where an individual was knocking off Panini's trademarks and selling them on what's bangbros.cards is what we called it was called the lawsuit there. But he was actually infringing Bang Brothers at the same time. In that case, he was sued, he was served, and he did not show up to court. And within 3 to 4 months, the court assessed a $600,000 fine against him. And that was just with trading cards. And I think I was just, with, maybe hundreds of trading cards that were at issue here. So you can see when you're talking about, potentially $4 million of declared value of submissions with 369 comics, I would think $600,000 might be the floor, might be the minimum that that the CGC could seek here. But it'll be interesting. I mean, I would like to see their damages theory. I would be asking for an amount of money that probably they wouldn't be able to pay, just as a deterrent for other people, because that's one of the things CGC needs to think about is they might want to make an example out of these two defendants to deter other people. So if they get a huge, several $100,000, $1 million verdict, somebody's going to think a lot, think a lot about, reholding something to make, $1,000, $5,000. That's a pretty big deterrent right there.
Right. Well, what about criminal case for this? Do you think that is the civil suit just sort of the beginning and then usually it does go to criminal case? Or do you think that CGC is going to be like, we don't want to go down this path of criminal aspects, wherever I assume that they're probably going to want to just get this, wrapped up as fast as possible so they don't have to ever talk about it again. But what would you expect a criminal charge here as well?
I think, yeah, because the criminal system and the civil system operate differently, because obviously the government would need to start a criminal case. Here, given the fact that CGC is moving quickly, that's why we haven't seen a counterpart criminal case, because CGC wants to shut them down now, so they moved as quickly as possible. Building a criminal case takes a little bit more time because the burden is higher. When you're bringing a civil case, it's just more likely than not is really it's just 51% really is what you're trying to get. Whereas for a criminal case, it's beyond a reasonable doubt. It's a much higher standard, so it takes a little bit longer to build that case. Will CGC want to press charges? Maybe. But here, if there are, potentially 369 other people that have been injured, I think the odds go drastically up that at least one of them might want to, start a criminal proceeding there. So I think eventually we might see that.
You would think like an individual person who was a victim might be the person that ends up filing that criminal case.
or would approach the authorities and have them file a case. Yes.
Gotcha. Yeah, of course. Yeah. My other question here, I guess, before we kind of like maybe move on to quickly wrap up the other case, the other lawsuit that's sort of going on is, just, I know you can't give legal counsel, but let's say you were someone who was a victim of this situation on different levels. Maybe you have 20 of these books that you bought that you ended up with, fraudulent books, or maybe you just have one of them. And CGC, I don't know what's actually working with them and how it's actually going, but they have a thing where it's like, hey, send us your book and we'll recoup you the money or through insurance or whatever it is. What would you do if you were somebody who like found one of these fraudulent books in your collection? How would you play this?
Yeah, I think it would turn on your on the dollar value, and because the reason I say that is because small claims court is an underutilized but a very powerful tool. But there's limits to the amount of the dollar value you can seek in small claims court. But if you were, you think you were ripped off here for, $4,000, $5,000, small claims court might be a really good place to go. It moves quickly. It requires, less, it still requires the same burden of proof, but it really requires less to do. And sometimes you don't even need a lawyer to do it. If you have, values over $20,000, $40,000, if not more than that, then I think at that point, you'd probably want to talk to an attorney and, because you'd probably be foreclosed out of small claims court and actually instituting a proceeding in either state or federal court, depending on where you are. But definitely, if you think you are, the unfortunate recipient of one of these 369 reholdered comics, I would definitely talk to a lawyer or at least, maybe start a small claims process if you feel confident enough that you could do that.
Gotcha. Other little thing in my comment section on some of my videos, I noticed the ones that get thumbed up the most. A lot of people have said, oh, there should be a class action lawsuit against CGC. Again, treat me like a third grader. Is there really a case here to have some sort of class action lawsuit? Is that really the thing that people would want to have happen? Is that, and is CGC worried about something like that popping up? What's your gut feeling on that?
So a class action lawsuit would mean that there's a group of people that have all been hurt in the same way. And so here, putting together that class would be, would it be the 369 people who bought reholdered comics? It'd be a little bit difficult to classify what that group is. If I'm CGC's attorneys, yes, I would be worried about something like this, especially since due to the size of the number of claims of reholdered comics that were here. Hopefully it's an isolated incident. If it's not, and if there is a flaw in CGC's process, there might be a potential class action for some type of breach of warranty type claim, breach of contract type claim. Everybody is thinking that they're buying the comic that's being purported here because the case is sealed. And, it's a tamper-proof case. Well, if it turns out the case can be tampered with and, some bad people know about how to do this and have duped a lot of people, you potentially could see that because because CGC isn't offering a tamper-proof case, and that's what people are paying for.
Right. Well, let's move on really quickly to the Terrazas case, which the Terrazas one was the couple who worked for CGC. Yeah. And it was funny because that one came out before this last one. But it was funny because as I was covering, your Twitter thread about it, it was a situation where I was like, oh, is this relates to the reholder? And it's like, oh, no, it's not. This is completely different. That one was two employees abusing, internal things where they could reprint, labels and swap in books. So sort of similar, but also very different. The things for that, the keywords are trademark infringement, which of course we have conversion, we have conspiracy, and we have unjust enrichment. Yeah. Can you just quickly summarize maybe what those differences are with the conversion, conspiracy, and unjust enrichment, and why those don't apply to this reholder one?
Sure. So the conversion claim, part of the claim and it's the Terrazas lawsuit, was that I believe Brandon Terrazas, as a former employee, was alleged to have actually taken some comics that were submitted. So he actually allegedly stole them. So that's where the conversion claim comes in. The unjust enrichment claim there arises because there are limitations as to what CGC employees can do. They're not supposed to submit comics for grading and then sell them. They're allowed to only submit comics for their own collections. So here they were submitting comics for grading and making money off of it. And sometimes we're, changing the labels or some, trying to dupe the process itself. So that's where the unjust enrichment comes in. And conspiracy is basically whenever you have more than one person engaged in an unlawful enterprise. That's where the conspiracy claim comes into.
Gotcha. And as far as going back, the revisiting of the slam dunk one, I mean, no slam dunks, but that one also seems like it's pretty straightforward, I would imagine.
That one does, because it's as part of the complaint, it indicates that an investigator spoke with Brandon Terrazas, and Brandon confessed to some of these things here. So as a plaintiff's attorney, I kind of like that. But as a plaintiff's attorney, you also look at what's the ultimate value of the case here. And at least from what's written there, this is orders of magnitude smaller, because it looks like only like $28,000 or $26,000 worth of comics may have been misappropriated or alleged to have been misappropriated there. So in that case, it might be too small for a plaintiff's firm to want to bring for that. But CGC's hiring people to actually win the lawsuit. They're not actually looking for the dollar value there.
Right. Well, I think that, those kind of cover the main sort of talking points. Were there any other little things, Paul, that, we kind of didn't really dig into with this case that are interesting, or is it really just a kind of a wait and see now? And I'm sure that, there will be new discoveries, but at the same time, it's it's going to go by the book, I suppose, in this situation.
There were, what I really liked about this, and, part of the reason I also tweet a lot about lawsuits is because I like to critique other lawyers and what they did. Here, the CGC attorneys did a great job. And, if you could pull it up for the pictures of some of the comics, they did a great side-by-side in storytelling of their case. So, if you click on one of those, they'll show the two comics that are at issue, and they actually have arrows showing how they did their detective work to figure it out. Because while it's hard to see, they have little arrows drawn to, for this Hulk comic, the original one had this Spider-Man in the corner. However, the one that was reholdered had the barcode. Right. And that is just great story. I mean, this is, I think, common people don't really care about this, but as a lawyer, that is such good storytelling, because a jury can understand, because this is for somebody who's not involved with comics, this is kind of complex. Reholdering, submissions, grading, that picture clears it all up. So, my, hat tip to the CGC lawyers. I think they did a very good job here. But as to timing, both of these cases are seeking temporary restraining orders. They should move quickly. I expect both of them will settle within 6 months. But it's neat to see that, trading card lawsuits. And I certainly hope there's more, because I take enjoyment out of stuff like this and branching out. And so I kind of hope there's more trading card or comic book lawsuits that are out there.
Yeah, well, the thing is, I'm sure there is more, and we'll definitely need you, Paul, to stay on top of this stuff and be the comic book whisperer as well, in terms of the legal stuff going on. But Paul, I just want to say thanks again so much for coming on the channel today and explaining this. It's been really, really, really helpful. If people have questions, or they want to get in touch with you, or they want to follow your work, maybe you can let people know the best way to stay in touch with everything that you do.
Yeah, so I'm on Twitter at Paul_Lesko. Every day before I start any work, I sit down with my hot chocolate. I look at all the legal filings in the trading card world and now in the comic book world. And if anything happens, I type them up. So if you have difficulties getting ready for the workday and you don't want to start working at 8:30 or 9 o'clock, just jump on Twitter and I'll show you what's happened overnight in all the trading card cases or all the comic book cases that are out there.
Awesome. Well, thanks again, Paul. It's been a pleasure talking to you. And we'll definitely have to have you on the channel again when other interesting, hobby legal things pop up in the future. So appreciate you taking the time, and we'll see you on the next one.
No, thanks for having me on. This was fun.